Okay, before we get started, this account was created to provide information on how current immigration laws apply to certain factual scenarios. There are many people, I suspect, who are worried about their immigration situation but are not sure if they should speak with an immigration attorney. Keep in mind, and I cannot stress this enough, that immigration law is unbelievably fact-specific. So even if the hypothetical that I analyze here sounds nearly identical to your situation, you still need to speak to an immigration attorney. These smallest factual differences can change everything. That said, this is not legal advice. I'm merely hoping to educate some people on how the immigration laws work, because I know that a lot of anxiety exists out in certain immigrant communities. Also, immigration laws and procedures will likely change significantly over the next few months, so what might be accurate and current at the time of recording could be outdated in the weeks to come or even tomorrow. This individual entered the United States without inspection and without a visa in 2002 at the age of 4. In 2012, when she was 14, she obtained DACA and has renewed it ever since then. Last year, she married her husband, who is a U.S. citizen. She wants to know if she can obtain lawful permanent resident status and what that process would look like. This might sound like a pretty familiar situation, but there are some wrinkles here that make it a little bit easier. So she entered the United States illegally. She was 4 years old. As you know, because we've talked about it before, you need to get a waiver for unlawful presence. So if you've been in the United States for more than 1 year with unlawful presence, then when you try and process a case like this, you need to get a 601A waiver, okay? But this is a little different because unlawful presence does not start to accrue until you are 18 years old. She received DACA when she was 14 years old. Even though she's been in the United States illegally for a number of years, the time spent in DACA status does not count towards unlawful presence. So she technically, under the immigration laws, does not have any unlawful presence. The reason that's important is that we don't need a waiver here. Okay, she's married to a U.S. citizen, so the first thing we would do would be to file a visa petition by the husband for her. That'll probably take about 12 to 14 months to get approved. Once that happens, then we're going to process the green card in Juarez. That's probably these days going to take another year. So the whole process will probably take about 2 years. But she won't need to get a waiver, which can add 2 or 3 years to that. So it simplifies the process because she has no unlawful presence. One thing with a case like this is that we always need to check to make sure that she never let her DACA lapse for a significant period of time. So let's say that she forgot to renew it on time and she accrued more than 6 months of unlawful presence until she renewed it. That could change things. Okay, so we would want to take a look at all of her approval notices for her DACAs since 2012, just to make sure there was never a period of time that she forgot to renew it and that could cause problem. If you're in this type of situation or this sounds remotely similar to you, it's probably best to talk to an attorney to see if you would be able to do a case like this without getting a waiver. You still need to go to Juarez, okay, so you can't get rid of that part. You can't do everything in the United States, but the Juarez trip will be 7 to 10 days and the whole process will take 2 years. Hopefully that helps. Let me know if you need my help on anything. You can call the office, you can leave a comment. Thank you.